So we obviously couldn't really speak about social media in Canada without talking about Quebec and the unique legal issues that are very specific to this market. And just to give you an idea of how prevalent and how popular social media is in Quebec, over 90% of Quebecers between 18 and 34 use social media actively. That number only goes down slightly to 85% for 35 to 44-year-olds and 76% for 45 to 54-year-olds. So with stats like that, the question really isn't whether we should be engaging with Quebec customers on social media. It's really how well we do that. And when we consider how well we do that, well, when you think about Quebec, that necessarily means in a way that is compliant with Quebec law and in a way that is respectful of the Quebec culture. But before we jump on the social media bandwagon, there are a few uniquely Quebec issues that you will want to consider, especially knowing that social media is not a risk-free zone. So the first is engaging with the young on social media. If you do that, that can be problematic. Quebec's infamous French language laws, and we're going to talk about how to translate your interactions on social media to comply with the law, and some rules on using testimonials as well. So if you advertise products that are intended for kids or products in a manner that may be appealing to kids, then you may be offside the Quebec Consumer Protection Act. So if you didn't already know, Quebec is one of only 3 jurisdictions in the world that prohibits commercial advertising to children, the other 2 being Norway and Sweden. So while we may hold the title for the only jurisdiction in North America to have these types of laws, I do want to mention that the federal government intends to introduce rules that will restrict unhealthy food and beverage advertising to kids and to teens as well. So it looks like those new rules will be far more restrictive than the Quebec rules actually. So the ban has been in effect for nearly 40 years, and if you think that advertising is lost on the young, then just consider that by the age of 4, children are able to recognize hundreds of logos. And there were studies that were done in Quebec, and the studies on the ban indicated that Quebec had lower childhood obesity rates, and there was actually a decrease in the consumption of fast foods in Quebec. So while that may not be good news for those of you in the room that are in the fast food industry, it is great news for Quebec children. And it's specifically those rising obesity rates in Canada that the federal government is trying to address by introducing restrictions on unhealthy food and beverage advertising. So the ban. The rule is that you cannot advertise to children under 13 years of age in Quebec. And in assessing whether or not your ad is considered prohibited advertising to kids, regulators will look at 3 factors. 1, the nature and intended purpose of the good. Are you advertising financial service products, or are you advertising toys, for example? Makes a big difference. The manner of presenting the ad. Does the ad use music, imagery, or characters that are appealing to kids? The time and place it is shown, of course. So are we talking about late night TV versus after school programming or Saturday morning cartoons? And the general impression. I do also want to highlight that it's not just manufacturers and retailers that can be held liable for advertising to kids. Ad agencies and anyone who distributes, publishes, or broadcasts an advertisement that is prohibited in Quebec can also be held liable. So the regulators have actually published a guide that can assist companies in complying with this rule. And this is an excerpt from the guide. And what you'll essentially see is that if the ad medium does not allow for reaching kids and your product is really intended for adults or children, then you're fine. But if the ad medium does allow for reaching children, then you need to take steps to ensure that your ad is not designed in a way that might be appealing to kids, even if the product is not necessarily intended for children. So if you have any doubt, I would definitely suggest taking a look at this guide. It is very helpful. Over the last few years, a number of companies have been charged and pled guilty to advertising to kids. And 2009 was a particularly eventful year. So in 2009, Lucky Charms pled guilty for inviting children to play games on their heavily branded website. And this is what the website used to look like. If you go to luckycharms.ca's French site, it doesn't look like that anymore. So although it's a bit of a dated case, it is significant because it was the first time that the ban was applied to the online space. So the ads were actually on the Lucky Charms cereal boxes, But what was the issue here was the advertising that was actually on the website. And what this suggests to us is that the ban will also apply to the social media world. So not just websites, but social media sites as well. I always mention the Saputo Igor muffin case for two reasons. One, because it was blatant advertising to kids, and two, because it had legal implications that extended far beyond just Saputo. So again, in 2009, Saputo launched this advertising campaign. You can see it here. It has CDs, posters, samples of the Igor muffin. And they distributed this to over 230 daycare centers in Quebec, so directly to the children. So kids would sing the Igor song, dance the Igor dance. You've got pictures there on how to do that. They would eat the Igor muffin and then likely go home and nag their parents for more. So Saputo pled guilty. They didn't contest the charge. They pled guilty and paid a fine. But what's notable about this case is that the ad agency that had designed this campaign was also charged and also pled guilty to advertising to kids. So again, it's not just the manufacturer or the retailer that can be held liable. The ad agencies are also at risk. More recently, Maple Leaf pled guilty to 5 counts of advertising to kids and paid a $10,000 fine for having broadcast a Top Dogs commercial during a French language children's network. Since Teletoon has its head office in Ontario, this case is significant because it marked the first time that, or really indicated that even broadcasters that are based outside of Quebec but that advertise in Quebec can be held liable under the Consumer Protection Act. Over the last few years, we've also seen the regulators go after things like logos on amusement park rides and signs at fairs. And so in 2015, CocaCola was charged and pled guilty and paid a $28,000 fine for their Fanta branded water ground at Six Flags in Montreal. So you can see that the water ground has since been modified and they've essentially removed all of the Fanta branding and coloring. But this was also a very significant issue and the fines were close to $30,000. We've also seen a tightening of the rules with respect to TV ads. So Think TV, previously Telecaster, has over the last few years received training by the Quebec Consumer Protection Office and has been taking the position that ads that are heavily branded or that show a child interacting or consuming a product merit a K or KK rating. And what that means as an advertiser is that you'll only be able to air your spot if 15 or 5% or less of viewers are under 13. So that's going to greatly restrict your media buy to generally the after 9 p.m. or after 11 p.m. time slot. So if you don't want to get one of those unfavorable ratings, then you definitely want to modify the ad, revise it so that you're not showing a child interacting with the product, which is very common in ads that we see in the States particularly, and that the ad is not heavily branded. And I'm just going to also mention that they tend to take that position more with respect to French television advertisements, but since the prohibition is in the Quebec Consumer Protection Act, it applies to both English and French media. So just to keep that in mind. And all these cases were initiated by the Quebec Wake Coalition, and that's a consumer advocacy group in Quebec that regularly files complaints with the regulators for things that it deems to be prohibited advertising to kids. They recently filed complaints with respect to coloring books and activity booklets that are distributed at restaurants, which if you've gone to restaurants that are kid-friendly, you know are generally very branded. And they've also recently filed complaints with respect to cereal box gifts and toys. Now, what's interesting though is that there is an exception to the ban when it comes to on-pack advertising. So technically, any advertising that is on a product packaging or labeling is exempt from the ban. So it'll be interesting to know how the regulators will address this complaint because not all complaints ultimately lead to penal prosecution or fines. So stay tuned for what that might look like. Advertising in Quebec obviously also has its own unique linguistic challenges. So we have the Charter of the French Language, which mandates that French is the official language of business and commerce in Quebec, and the Office Québécois de la Langue Française, the OQLF, which is mandated with ensuring compliance, ensuring that companies comply with the Charter. So the charter has hundreds of provisions, but for the purposes of this presentation, there are 3 basic advertising rules that you want to consider. The first, and it's not really relevant for social media, but I thought I'd mention it anyways, product packaging and labeling. Product packaging and labeling, so every inscription on a product, on its packaging, labeling, or documents supplied with it needs to be in French. It can be in a language other than French as well, provided that the French version is equally prominent. So equally prominent in terms of placement, in terms of font size and content. So you'll see here that the Laughing Cow is translated in French, same size font, same placement. Everything that is in English on that primary packaging is translated to French in the same size font. Second rule concerns catalogs, brochures, and commercial publications. So think the IKEA flyer, for example. Those are also subject to the equal prominence rule. So they either have to be exclusively in French or equally bilingual. You can also have a French version and an English version, provided you've got an equal number of versions. So the third rule concerns commercial advertising, and so that is billboard signs, posters, any sort of point of sale materials. The rule for these types of materials are different. So the French needs to be markedly predominant. And what that expression really means is actually the object of its own regulation. But generally, if you've got English and French on the same poster, for example, then we call it the 2/3 rule. It needs to be 2/3 French, 1/3 English. So French needs to be given much more predominance. I also like to mention it's not a social media issue, but there were new signage rules that came into effect last November, which require companies to add French to their signs in Quebec, their outdoor signage. So if that is something that is on your mind, feel free to come see me later and we can talk about that. So since the charter was enacted back in the 70s, prior to the internet becoming mainstream, you're going to be hard-pressed to find any words like website, email, social media, internet, anything like that. And that's probably why I get so many calls from clients saying, well, where does it say in the charter that my website needs to be in French? Like, I've read it over it, I don't see that anywhere. And that is because the regulators have taken these archaic rules and they've kind of interpreted them and adapted them to the realities of today. So they take the position that websites and emails are electronic versions of the second rule, the rule on commercial publications, that IKEA catalog rule. So websites and electronic messages are assimilated to catalogs, brochures, and similar publications. They're just in electronic form. And so those need to abide by the equal prominence rule, which means that if you're subject to the charter and you have a website, you need to have an equivalent website, French website. Equivalent, again, in terms of content, font size, overall material presentation. If you send emails, emails are also considered an electronic form of a commercial publication. Your emails need to be either completely in French or equally bilingual. There is, however, an exception that applies specifically to emails, and so the charter provides that you can send an English only or a non-French email to a physical person who has expressly requested to receive those types of documents in English only. So in this kind of post-Castle era, when you're asking for consent, you can ask for their language preference. Just be sure to retain and record that consent in case you're ever challenged. And we spoke about commercial publications, including websites, where there are exceptions that apply to different types of, or specific types of commercial publications. And so logically, those exceptions should apply to websites or social media sites that fall within this exception. So a commercial publication, so think website, concerning a cultural product or educational product, like a book or a film, can be exclusively in that other language, provided that that content of that product is in that language. So a website or social media page about a movie, for example, an English language movie, could technically be exclusively in English. The same goes for a news medium. So Montreal Gazette, for example, publishes in English only. Their website and social media pages should logically benefit from this exception. And when it comes to social media, we've always taken the position that a company's social media page or pages are essentially an extension of the company's website, and so that they are also subject to the charter and that commercial publications rule. So in 2015, the OQLF unofficially took that position during the whole Delilah incident. So in February of 2015, Delilah, featured here, received a letter from the regulators essentially stating that all of her posts on her company's Facebook page were only in English and ordering her to translate those to French or risk being fined. So after taking to social media, as many business owners do in Quebec when they receive letters like this, the OQLF withdrew their threat of complaints on the promise that going forward, her corporate posts would be bilingual. The OQLF also agreed that greater guidance and clarity was needed with respect to how the charter applied to the social media space. And so fast forward a year later, they finally filled that regulatory interpretation void by publishing a guide entitled Social Media and the Charter of the French Language. So although the guide does not have force of law, it's really only for informational purposes, it does give us a deeper understanding of how the regulators apply the charter to the online space. And essentially, if your company is based in Quebec or has an establishment in Quebec, the social media site is used by the company in its official capacity, so it's not a fan page, for example, and the social media content concerns the Quebec market, then you're subject to the charter and it needs to be in French. So again, when we talk about content that will be subject to the charter, anytime you're posting something of a promotional or advertising nature that concerns Quebec without needing to be exclusively intended for the Quebec market, that needs to be translated. And the guide also confirms our opinion that the charter doesn't go so far as to require you to translate customer posts to French, right? Just the ones that are coming from the company, emanating from the company, need to be translated to French. It also doesn't require you to respond in French to someone's question that may be in English. But if obviously a customer asks a question on social media in French, you would want to respond in French. Okay, I don't have much time, so we'll go quickly through the rest. And if you want to weigh the risks of compliance versus non-compliance, there are regulatory fines. There's also negative PR, right? So bear in mind that French language issues are a very sensitive topic in Quebec, and so negative PR can result even if the regulators decide not to act. And to give you an example, there was a major retailer, and when we talk about French, we don't just talk about making sure the French copy is there, we're also talking about the quality of the French copy. Do make sure that the quality of the French that you're using is appropriate. And so here's an example of a major retailer who advertised this dumbbell storage rack on its website, and you won't be able to make that out, but they essentially, I'm assuming, used something similar to Google Translate and described the dumbbell storage rack. So they translated dumbbell to moron or idiot and described the product as an efficient way to store and hold your morons. So it's pretty unfortunate, but you do want to take care to ensure that the quality of your French copy is appropriate, because you don't want to be the company that's making headlines for being insensitive or disrespectful to the French Quebec market. Morons, yeah. Testimonials. So Dan spoke about this, so I'll go over this fairly quickly. But if you want to collaborate with influencers, I mean, it's a great way to engage customers and create buzz and excitement about your brand, but you want to do it in a way that is compliant. And there are both federal and Quebec-specific rules with respect to this. So under the Federal Competition Act, testimonials need to be the actual honest and true opinion of the person giving them. That goes without saying. The Competition Bureau, as Dan mentioned, will go after things like fake reviews. And I was actually at a seminar 2 days ago that was given by Ad Standards, where they revealed that 80% of Canadian consumers are less likely to purchase a product if there are fake reviews on your site. So that really indicates that lack of transparency can not only cause penal issues for you and fines at the federal level, but can also be detrimental to your bottom line. Similar rules in the Canadian Code of Advertising Standards. Needs to reflect the genuine, reasonably current opinion of the individual. Consumers are notoriously fickle, so do ensure that you're using up-to-date data. And they need to be based on the person's actual experience with the product. So make sure that the person who's tweeting or blogging or vlogging about your product has actually used it, and they've used it fairly recently. You've also got the general, thou shalt not lie, false and misleading provisions that you'll find in the Federal Competition Act. You'll find it in provincial statutes as well. The Competition Bureau interprets that as meaning that you cannot conceal the commercial intent behind a post, for example. You need to be clear as to the relationship between the person making that representation and the supplier of the product. But in addition to the false and misleading rules that you'll see in the Quebec Consumer Protection Act as well, there is one rule that is specific to testimonials. And it provides that you cannot falsely hold out that a person has recommended, approved, certified, sponsored, or endorsed your product. So while the Quebec regulators don't have any sort of policies that interpret that provision, we find that they generally tend to rely on whatever the federal government uses. And so Competition Bureau recommends that for online disclosures that you comply with ASC's guidelines on testimonials. And what those guidelines state, for example, is that a representation will be false and misleading if you do not disclose the commercial intent, the commercial relationship, or the relationship between the person making the representation and the brand owner, for example. The nature of that material connection needs to also be clearly disclosed. So if you're paying for the post, say that. If you provide the product for free, say that as well. And it needs to be in close proximity to that post. So to the extent that you've collaborated with a vlogger, that disclosure needs to be at the very beginning. It cannot be once you're 5 or 10 minutes into the video. If you want examples on how to disclose the material connection, the FTC also has a guideline on that. And the Competition Bureau also suggests that you check out the International Consumer Protection and Enforcement Network's guidance documents. There are 2 guidance documents. There's one for marketing professionals and another one for digital influencers. And what all of those guidelines, the ASC's guidelines on testimonials, the International Consumer Protection and Enforcement Network guidelines, and the FTC's guidelines, what they all underscore is the importance of transparency and ensuring that you adequately disclose when consumers are being fed advertising content. And if you don't disclose that material relationship in a manner that is compliant, well, that can be very costly in Quebec because of that specific rule on endorsements. We've seen in the last few years the regulators go after companies with fines that are far above the minimum fine of $2,000. And this is specifically with respect to the telecom and automotive industries, where the regulators have gone after companies by issuing a large number of fines totaling in the hundreds of thousands of dollars. And so what that means is that if you're going to engage in conduct that is contrary to the Consumer Protection Act, well, it might be more cost prohibitive now than it may have been a year or 2 ago, especially for larger companies who, according to the regulators, should know better.